Hello and thank you for joining us. This webinar marks the launch of a new report from Korea Future that asks a simple question with serious implications. What does justice look like for North Korean survivors in 2025 and the coming years? We spoke with survivors across the diaspora, including underrepresented voices, women, older people, those living with disabilities, and survivors of sexual and gender-based violence. The picture that emerges is clear and in many ways different from a decade ago when a United Nations Commission of Inquiry delivered its findings. Today, 70% of survivors we engage prioritize prosecution of those most responsible. Survivors want lawful processes that lead to individual criminal responsibility, not just findings of state responsibility. At the same time, they do not want to wait in silence for a court date that may be years away. Over 40% identify psychosocial and medical support as an important form of reparation. Many also saw value in people's tribunal-style forums that preserve testimony and sustain visibility, and in targeted human rights sanctions that name perpetrators and restrict their movement and assets. UN human rights mechanisms remain useful when they recognize harm and keep facts on the record, but they were not seen as substitutes for trials. Today's webinar and the experts who will speak expand on these preferences. First, we will explore criminal responsibility and what it takes to build cases that move beyond crime-based description to linkage and attribution. Then, we will learn why rehabilitation is itself a recognized form of redress and how it enables safe participation in legal processes. We will hear about people's tribunals, what they can credibly deliver, and how they support rather than preempt future prosecutions. And we'll look at UN processes and separately the potential of targeted human rights sanctions. Before starting, I want to thank the German Federal Foreign Office for supporting this work and for their commitment to a survivor-centered justice agenda. As someone from the North Korean diaspora, I can say that we are grateful for their support and for their prioritization of justice.
Stephen Rapp. I was an international prosecutor at the Rwanda and Sierra Leone tribunals, bringing the case of the Sierra Leone tribunal, convicting a president of the neighboring country of Sierra Leone, President Charles Taylor of Liberia. Thereafter, I served as U.S. Ambassador at Large for Global Criminal Justice for 6 years, working on trying to find pathways to accountability around the world for similar atrocities. And in the 10 years since I left the State Department, I've been involved with NGOs such as CIJA, where I'm proud to be chairman of their board of commissioners, working and particularly with the civil society organizations and people on the ground in developing the strong evidence that will be needed to bring cases in court. These cases, which are, of course, at the end of the day, only brought against those individuals that are available, and that may not deal with the whole structure and the whole system of violation, can be extremely meaningful for the victims and survivors. The opportunity to confront a perpetrator with the evidence against him, and to speak in a courtroom, leveling the situation where before that perpetrator had all the power of life and death over an individual and his family and his whole society, and suddenly that individual has to answer to the law and to answer to the victims and survivors. And when that evidence all comes together, and when independent judges find that individual has been involved in an international crime, a crime of atrocity, crimes against humanity, war crimes, even sometimes genocide, even though it's only one individual, and there's so many others that aren't before the court, it's a moment of immense satisfaction and even joy for the survivors, and that's one of the things that gratifies me in being involved in this process. Well, the key lesson in all of this is that one needs strong evidence, and particularly linkage evidence, that can connect perpetrators to the crimes on the ground. And that can be even more challenging in these universal jurisdiction cases where you don't have the top leader, who sometimes you can hold responsible as the top superior who's responsible for the whole system. You've got one of the cogs in the machine. And that's why one really needs to develop the evidence about that machine, that machinery of torture and death and repression. and understand the various offending structures, whether they be military or secret police or private militia or whatever it is that the regime is doing to make possible the commission of these horrendous crimes. And so the key at the end of the day is the strength of the evidence and one's ability to link individuals criminally to those offending structures. And fundamentally, I think if one can do that and build a strong framework of evidence, then there will be opportunities. It's if you build the case, even though it may seem very difficult, you can find judges that will come to a trial. You'll find places, countries that are ready when that evidence is so strong to meet their jurisdictional requirements and to hold the perpetrator to account. So key evidence, strong evidence, but particularly on the linkage and on the structure of those parts of the state that are involved in the criminal conduct.
My name is William Wiley. I'm the founder and executive director of the Commission for International Justice and Accountability, CIJA. The purpose of CIJA as a nonprofit foundation is to collect evidence and information in what are otherwise, for our colleagues who remain in public service, non-permissive environments. Environments that our public service colleagues cannot access for reasons of political diplomacy or indeed, in many cases, physical risk. The point of getting into these areas in support of the public sector is so ultimately the colleagues in public sector have sufficient evidence to bring criminal cases against most especially high-level perpetrators. And here I refer to typically security intelligence officers, military personnel, and political actors. In my experience, and indeed as a matter of law, you can't compare investigations, human rights investigations, and investigations pursuant to international criminal and humanitarian law, because the objectives are quite different. The human rights colleagues are seeking to hold a state responsible, whereas it's much more complex as a matter of international criminal and humanitarian law to hold an individual responsible. So in a nutshell, it's necessary to find ultimately evidence of individual criminality, or most especially individual criminal intent, where individuals fit into chains of command, ideally high up those chains of command. This is the key to ICHL investigations, successful ICHL investigations, and it requires incredible attention to evidentiary detail. And in non-permissive environments such as North Korea, it requires a great deal of cunning and guile to acquire prima facie evidence. Typically in an international criminal investigation, we put evidence or prima facie evidence into two categories. On the one hand, crime-based evidence, and on the other hand, linkage evidence. In the case as a whole, crime-based evidence is typically going to be about 10% of the material required to convict a particular individual, particularly a high-ranking individual. Crime-based evidence is specific to the death, mayhem, torture, sexual offenses, murder, and such like at the material or physical level. It corresponds, roughly speaking, to the material elements of a given crime, such as murder and so forth. Linkage is, as I've suggested, a much more complicated issue. It's focused principally around the command, control, and communications arrangements of perpetrating structures in the first instance. Effectively, one needs to understand the way in which a particular security intelligence service or elements thereof, or a particular military or formations and units thereof operated. Once you understand that, you understand who's in command or was in command of these perpetrating structures. You link that to the crime base, and therein you have your suspects, or ultimately, if you could get your hands on them, you have your accused. So This is ultimately goes to the distinction between a human rights investigation, which is invariably focused on crime base, and international criminal investigation, which is much more heavily focused on linkage evidence.
أنا حسن الحريري، محامي من سوريا. عملت في المحاماة فترة طويلة قبل اندلاع الثورة السورية في العام 2011، وهذا ساعدني أني أكون مدافع عن حقوق الإنسان وعن الحريات كوني محامي. انضميت لفريق سيجا في العام 2012، وكنت أشغل مهام رئيس فرق التحقيقات. طبعا فرق التحقيقات هي عبارة عن مجموعة من المحققين المنتشرين داخل أراضي الجمهورية العربية السورية، يقومون بمجموعة من المهام، على رأسها مهمتين أساسيتين. المهمة الأولى تتمثل بجمع الأدلة والحفاظ عليها، والمقصود بجمع الأدلة مجموعة المستندات والوثائق التي كان يسيطر عليها الجيش الحر والفصائل العسكرية عندما يتم الاستيلاء على منطقة كان يسيطر عليها جنود النظام. فتأتي فرق التحقيق الخاصة بمنظمة سيجا وتقوم بجمع هذه الأدلة تمهيدا لتحليلها واستثمارها في المحاكمات. أيضا المهمة الثانية التي يقوم بها المحقق تتمثل بجمع الإفادات، والمقصود بجمع الإفادات أخذ شهادات من شهود العيان، من الجنود المنشقين، من كبار الضباط المنشقين، من أهالي الضحايا، وكثير من الأحيان من الضحايا نفسهم الذين نجوا من سجون الدكتاتور بشار الأسد. إذن هذا مهمة أساسية يقوم بها المحقق، وهي تساعد كثيرا في المحاكمات. لم نكن يعني على يقين تام أننا سوف نرى محاكمات أثناء بداية العمل، لكن عندما جمعنا هذا الكم الهائل من الأدلة وتم استثماره في المحاكمات التي جرت في عدد من الدول الأوروبية، وكان لهذه الأدلة التي تم جمعها وهذه الإفادات التي تم أخذها من الجنود ومن الشهود كان أثر كبير جدا في نتيجة المحاكمات التي أدانت مجرمين أساءوا بحق الشعب السوري. لذلك كانت الفرحة كبيرة، وزاد اعتزازي على المستوى الشخصي وأيضا زملائي في فرق التحقيقات من ثقتهم بأنفسهم، وأنهم يقومون بإنجازات كبيرة جدا تخدم العدالة بشكل عام، العدالة الجنائية بشكل عام، وتخدم الشعب السوري بشكل خاص، وتخدم جميع من يعني يؤمن بالحرية وبالعدالة وبالإنسانية. لذلك رسالتي إلى جميع الناشطين والمهتمين والحقوقيين في كوريا الشمالية: لا تيأسوا. يعني ممكن أن تكون العدالة بعيدة، لكن هذه العدالة قطعا تحتاج إلى يعني عمل دؤوب جدا، تحتاج إلى إصرار، تحتاج إلى إيمان وقناعة بأن هذا العمل يحتاج إلى صبر، ويحتاج إلى إخلاص، ويحتاج إلى مثابرة. ومن ثم العدالة بتصوري الشخصي هي تحصيل حاصل بناء على الجهد الذي سيقوم به مجموعة الناشطين، مجموعة المؤمنين بفكرة العدالة. الآن نحن نستثمر الحقيقة الجهد الذي بذلناه خلال السنوات الماضية، ربما أكثر من 12 عاما 13 عاما، ونحن نجمع الأدلة ونقوم بتحليلها ونقوم برصدها، واليوم يتم استثمارها في المحاكمات الجنائية التي تدين المجرمين الذين ارتكبوا جرائم حرب وجرائم ضد الإنسانية بحق الشعب السوري. وفي المستقبل أيضا يعني نتمنى أن نشاهد هذه الأدلة يعني يتم استثمارها بشكل أكبر في المحاكمات التي ستجري على أراضي الجمهورية العربية السورية بناء على القوانين الوطنية أو بناء على يعني محاكمات مختلطة. لذلك رسالتي اصمدوا واعملوا بصمت وبدون إعلام، والنتائج ستظهر قولا واحدا، والحرية تستحق أن يتم العمل من أجلها. شكرا.
My name is Yezin, and I work as head of client experience at Connect North Korea. We are a charity that works with North Korean escapees to recover, rebuild, and succeed. Today, I want to talk about psychosocial and medical support and why we believe it can become a form of justice. At CNK, we offer safe, confidential support to North Korean asylum seekers and refugees. People can speak to a trained therapist alone or in small groups. We also help escapees see a doctor when they need medical care related trauma. We explain what will happen, we ask for consent, and we keep information private. Survivors choose how much they wish to share, and they can stop at any time. Why do we see this as justice? Because the harm was not only in the past, it lives in the body and the mind. Many of our clients tell us about panic, nightmares, sudden anger, or shame that blocks their life. Good therapy, therapeutic engagement, and trauma-informed medical care recognize that harm and work to repair it. Recognition has dignity. It says what happened mattered, and you matter. In international practice, this is called rehabilitation. Rehabilitation is a form of reparation. It is not charity, it is part of a remedy. Psychosocial support also helps survivors take part in legal processes if they choose. Trials and investigations take time. They also ask a lot from survivors. With steady support, people sleep better, manage flashbacks, and feel more in control. This means they can take clear choices about giving a statement, attending a meeting, or writing to an official. When someone does decide to speak, therapy reduces the need to retell painful stories many times and helps them prepare for hard questions. In short, support protects people and improves the quality of any future evidence. Our approach is survivor-centered. We start with safety, then choice. We match survivors with therapists who understand the North Korea context. We schedule sessions around work and childcare. Our work is not instead of prosecutions. Survivors in the UK are often very clear that they want those responsible to face the law. Psychosocial and medical support sits next to that goal and makes it more possible. It delivers a real benefit now, and it strengthens the path to accountability later.
Some years ago, I was working on the North Korea inquiry in the UK Parliament. The inquiry was to examine the progress made after the UN Commission of Inquiry report published in 2014. The parliamentary inquiry was led by Lord Alton of Liverpool. As we were collecting and analysing data, and as we were hearing stories of victims and survivors, very quickly it became very clear that we're far from where we should be right now in terms of justice and accountability for victims and survivors of the horrific atrocities in North Korea. Unfortunately, the situation in North Korea is not gaining the attention it requires, attention that is reflective of the nature and scale of the atrocities in the country, an attention which could turn recommendations into action. One of the recommendations of the Commission of Inquiry that I have been looking into was the UN Security Council referral of the situation in North Korea to the International Criminal Court. 11 years later, this has not been done yet. And only a few weeks ago, we saw how this step, a referral from the UN Security Council, can translate into some justice and accountability, with the first conviction in the case of Ali Mohammed and Ali Abd al-Rahman, who was found guilty of 27 counts of crimes against humanity and war crimes in Darfur, Sudan, between 2003 and 2004. A very small step, but a step which is still not a prospect for victims and survivors of atrocities in North Korea. We must look at how the principle of universal jurisdiction could be used to serve justice. We must look at how people's tribunals can assist in situations where other options are severely limited. And while people's tribunals, such as the China Tribunal, such as the Uyghur Tribunal, and many others, cannot deliver enforceable judgments, they can play an important role in establishing truth about gross human rights violations. They can help to shine a light on situations which otherwise do not get the attention they require. And above all, they provide victims and survivors with a platform to tell their stories, share their suffering, and be heard. The atrocities in North Korea require us to look at all the tools in the toolbox. This is for victims and survivors to ensure that justice and accountability is served, but also to use justice and accountability to prevent future atrocities.
The Special Rapporteur on the Situation of Human Rights in the Democratic People's Republic of Korea was established by the United Nations Commission on Human Rights in 2004 and has been renewed on an annual basis by the Human Rights Council. My role involves investigating and reporting on the situation of human rights in the DPRK and on the state's compliance with its obligations under international human rights law. I submit reports to the Human Rights Council and the General Assembly annually. The UN system contains a wide range of human rights monitoring mechanisms, all within the framework of international human rights law. Broadly, there are two types of human rights monitoring mechanisms within the UN system: treaty-based bodies and charter-based procedures. The 10 human rights treaty bodies are made up of committees of independent experts who monitor implementation of the core international human rights treaties. The charter-based procedures include the special procedures, the universal periodic review, and independent investigations. To ensure human rights standards and commitments are upheld around the world, including in the DPRK, monitoring is a critical component of human rights work. Here, the role of survivors and civil society is especially critical. If you are a survivor of a human rights violation, you can turn to one of the two mechanisms: special procedures, which include my office, and treaty bodies. My office can receive information through secure channels. Submissions work best when they answer 4 questions: who was harmed, by whom, when and where, and what sources support the account. With informed consent, I can raise individual cases through urgent appeals or allegation letters, include patterns in my public report, and brief states and UN bodies. I can also transmit material, with your permission, to other relevant mandates, such as torture and violence against women. The expected outcomes are public acknowledgement, official communications to responsible authorities, and recommendations that member states can use to shape policy and targeted measures. Even where individual complaints are not available, you and civil society organizations can file shadow reports and give briefings to the Human Rights Committee, the Committee on Economic, Social, and Cultural Rights, the Committee on the Elimination of all Forms of Discrimination Against Women, the Committee on the Rights of Persons with Disabilities, which, by the way, in September of 2025, issued its findings and recommendations on the DPRK. These processes set legally grounded standards, produce authoritative findings, and keep issues on formal agendas. Finally, the Human Rights Council March session is a moment when evidence and recommendations can support resolutions in bilateral diplomacy. Survivors can speak through accredited NGOs, meet with missions in Geneva in general. Of course, these mechanisms are not substitutes for criminal prosecution, but they are meaningful steps that keep pressure on duty bearers and protect the pathway to individual accountability. I encourage you to engage with the United Nations mechanism. My office stands ready to work with you so that the facts are preserved, your voices are heard, and states are moved to action while the longer criminal work advances. Thank you for your attention.
Hello, my name is Tinatin Tsertswadze. I work at the Open Society Foundations as advocacy advisor, focusing on European Union policies and Europe broadly. In this video, I will explain how EU sanctions policies function and some basic facts around them. EU sanctions are part of EU's common foreign and security policy toolbox, and they're most effective when utilized in combination to other policy tools. Civil society primarily focuses on so-called targeted individual sanctions. EU has quite a big array of the toolbox for sanctions at the moment, over 40 country-specific regimes and 5 thematic regimes. One of the regimes is global human rights sanctions regime, which is used by the EU to target those who commit grave human rights violations. Targeted human rights sanctions regimes are different from broad-based economic sanctions. These broad-based economic sanctions primarily target whole states, whole economies, economic sectors, and there's a growing evidence that this type of sanctions increasingly harm the ordinary population, but at times of war, sometimes not to use the military means, EU does resort to the economic sanctions. With targeted sanctions, EU identifies specific individuals or entities allegedly complicit in specific human rights violations, which are already enlisted in a specific regulation, and they range from grave crimes such as crimes against humanity, torture and ill treatment, enforced disappearances, to violations such as violations of freedom assemblies, expression, gender-based and sexual violence, and several other violations in between. EU sanctions decision-making process differs from single jurisdiction sanctions decision-making process. As a rule, sanctions can be proposed on specific individual or entity by High Representative of the European Union, currently held by Kaja Kallas, or a member state or a group of member states. Once the proposal is made, then the discussions take place within the Council among 27 member states, and for any EU sanctions to be effective, it needs to be adopted by 27 EU member states, what you call unanimity rule. And despite this cumbersome process, there is, as I mentioned, quite a number of EU sanctions in place already, and there is a process how this can move quickly. Sometimes the process can be slow. In terms of what sanctions means or how different they are from criminal proceedings, there's quite a big difference, and it's very important to understand that sanctions are not there to replace criminal processes or to replace any courts. Sanctions by and large are self-imposed, self-implemented and administrative processes. The courts are not involved, there is no court proceedings or judgments. It's effectively a policy and political process in response of and condemnation of the grave human rights violations. Let's say if a statement by the EU or démarche doesn't prevent continuous violations of human rights, the sanctions will be the next step of escalation, and I would say the last step of escalation. They are not by any means to replace any criminal processes, and they could be complementary, and there are a number of examples of that from the past. Sanctions, I would characterize, are the most consequential foreign policy instruments, because when individual or entity is sanctioned, the consequences they suffer is they cannot access territory of the European Union, and if they hold any assets, whether it's liquid or in real estate or in arts or in any other form, those assets will be frozen or immobilized. Now, freezing or immobilizing the assets doesn't mean they are not in the ownership of the same individuals. The ownership of the assets doesn't change by means of the EU sanctions, but individuals or entities will not be able to make use of these sanctions. In addition, EU citizens have the obligation to comply with EU sanctions, which means that no EU entity or no EU individual will be permitted to provide any types of services to sanctioned individuals, be it grants, loans, participation in procurement processes, participation in EU grant financial schemes, and any other like legal services, economic services, polling services, or any other services. Now, individuals who are sanctioned by the EU have the right to appeal their designation. As a rule, when somebody is sanctioned, they are informed by the EU and they're informed of their right to appeal. It's one of the few jurisdictions where such appeal exists, and appeal happens at two levels. Individual can go to through administrative process and presenting to the Council of the EU evidence that they have not committed alleged crime. If this route doesn't work, then individuals can go to the European Court of Justice in Luxembourg and appeal their designation there. Now, European Court of Justice reasoned a couple of years ago that sanctions, because they're a foreign policy tool, need to comply with EU foreign policy objectives. They need to comply with the listed reasons for a statement, and they need to provide the evidence that is on the basis of sufficiently solid factual basis. If all these three requirements are satisfied, then as a rule, the court takes view that individuals will remain listed. If any of these components are not satisfied, then there can be delisting, and there's a history of delisting in the EU over the last 10-15 years, and this is a possibility that this can happen, and this has happened in the past. That's all for now, and let me know if you have any questions.
Thank you to our speakers for the clarity and care they brought to this conversation, and to the survivors whose preferences guided the discussion. Let me close by drawing together the lessons learned and setting out what comes next. The message from survivors is consistent. Justice must attach to named people through fair trials. Services that address trauma are part of justice, not a consolation. Expressive forums and UN mechanisms retain value when they are honest about their limits. And targeted human rights sanctions are a practical way to create consequence now. Read together, these are not competing tracks, but a sequence that keeps survivors safe while the law catches up. On the strength of that record, our recommendations are straightforward. First, states must prioritize case building for criminal accountability. Second, foundations and governments with diaspora population must support psychosocial and medical care as a part of justice and recognize rehabilitation explicitly as a form of reparation. Third, people's tribunals should be explored carefully and clearly where they add value. Fourth, civil society must continue to leverage UN human rights mechanisms for visibility. Finally, states with legal regimes must apply and maintain targeted human rights sanctions and communicate outcomes so survivors can see the consequence. We again thank the German Federal Foreign Office for funding this project, our speakers for their expertise, and all of you for your time and attention. If you would like to receive the report, please visit our website.